Welcome to the Three Questions webcast series. I'm Wayne Baxter with One Capital Management. At One Capital Management, we develop and implement strategies for our clients which strive to grow, protect, and ultimately distribute their wealth. And we do that by offering investment wealth management services. Thank you for taking time to check us out. My clients are often referred to as cross-border clients. Now, why is that? Well, it's because they're either U.S. or Canadian residents who invest in U.S. and or Canadian dollar-denominated securities like stocks, bonds, or ETFs. Our process for advising our clients include an in-depth discovery and diagnostic analysis of their wealth management goals and objectives. The goal of the Three Questions webcast series is to educate and inform you about some of the financial issues that you may encounter, and in doing so, introduce you to some of the experts that you may be able to assist you. On this edition, we're going to talk about how Canadian entrepreneurs can protect their proprietary products and branding through the lens of a United States-based intellectual property and patent attorney who provides services to Canadian business owners here in the U.S. On this edition of the webcast, we'll be asking the three questions Canadian entrepreneurs should ask before they sell their branded and proprietary property into the United States. Joining me from Frisco, Texas in the Dallas-Fort Worth area is Mark Nielsen. Mark is an experienced intellectual property attorney, and he is also a partner with the law firm of Scheef and Stone. Mark's practice primarily focuses on all aspects of intellectual property, including litigating, patents, trademarks, and copyrights. Well, Mark, here you are. Welcome to the webcast. It's great to see you.
Thanks for having me.
You're properly attired. A little bit of inside information here. Maybe you should tell our audience what you had hoped our webcast would be.
Well, Wayne, you and I are both big hockey fans, and if you lock us in a room together for 3 hours, we could entertain ourselves talking about hockey nonstop.
For 3 hours.
But, I don't think your clients would want to hear about that. They'd rather hear about something business oriented, although I could be wrong.
Like we'll ultimately may find out in the comment section of our webcast, but yeah. So I'll give you this, Mark. Even though you were born and raised in Southern California, Pacific Palisades, as I recall, I would put you in a Tim Hortons coffee shop in Fort Saskatchewan, and I'm pretty sure you could hold yourself in any conversation about the NHL anytime, 365 days of the year. So that's my kudo to you.
Well, thank you.
So now that we're going to change back to the task at hand here, before we get into our three questions, why don't you take a couple minutes to talk about branded and proprietary property? Now, as I understand it, what we're talking about here is an ever-widening landscape that covers a lot more areas of products and services. So maybe you could just give us the, as they say in the United States, the Cliff Notes version of what we're talking about.
Sure, and thank you again for having me. So what I deal with in my law practice is intellectual property, and intellectual property is patents, which are inventions stated very broadly, trademarks, which is branding, again stated very broadly, copyrights, which covers creative things, music, artwork, literature, sculpture, things of that nature. And then also there's a category of intellectual property called trade secrets. Trade secrets are things that are confidential but have value because they are confidential. Good examples of that would be the formula of Coca-Cola, Google's algorithms to run their search, things of that nature. Because
the secret recipe for the chicken would be another example.
Kentucky Fried Chicken, WD-40, things like that. And they derive value from the fact that their formulas are not publicly known. So I deal with all manner of clients all over the place who have businesses that are either in those areas, they need these types of rights protected. Unfortunately, sometimes they may violate these types of rights. And a lot of times, even in deals where clients are in the process of buying or selling their company or another company, consideration of these issues related to intellectual property has to be dealt with, even if it's as simple as just making sure For example, if you're buying a company and that company has certain intellectual property rights, patents, trademarks, what have you, that those rights are just transferred properly as part of that purchase. So it's pervasive. And you know, a lot of studies, economic studies have been done by the United States, and I'm sure other countries as well, about the contribution that intellectual property makes to the overall economy, and it is significant. So, you know, fortunately for me as an intellectual property lawyer, IP is pretty much everywhere.
So I think one of the first thing I'm going to pick up on here with our discussion is that you could represent the aggrieved, the person who's been trodden upon, if you will, or also the client who actually inadvertently maybe goes off the ranch and inadvertently maybe is the one who is actually committing the proverbial offense.
Absolutely. I've been doing this for 22 years plus and have represented plaintiffs, have represented defendants in these types of cases. Certainly worked with companies to help them, and individuals, in fact, to help them protect their rights. And sometimes people come to me and say, if I wanted to do this, would I get into trouble? So you have to do a search, you have to do some analysis and see what is out there. And you advise clients that way as well. They want to open up a new business and they want to have some name for it. And you would search trademark registries, maybe other types of corporate listings and whatnot to see if the name is clear. You do a clearance search, basically.
So Mark used the term plaintiff and defendants. Once again, proving his legal expertise as opposed to the aggrieved.
That's a fair way to characterize it.
Yeah, so, fair. Yes. Okay, so you know what? We should carry on here and let's talk about the 3 questions that Canadian entrepreneurs should ask before they sell their branded proprietary property into the United States. And the first one, I guess, is rather an obvious one. Probably sort of we're starting at 101 is, as a Canadian entrepreneur, can I protect my branded and proprietary property that I'm looking to sell into the US? So the first question is there a way for me to do that?
Oh, absolutely. As any decent lawyer will usually preface their answer with an "it depends." And it depends on the specific facts and the specific types of rights that you want to protect as a business owner. If you are a company that is very active in research and development and you've come up with a better mousetrap, or you've come up with a new compound that makes hair regrow better or something like that, those rights can be protected worldwide, including in the United States, provided that effort is made quickly enough to begin the process of applying for patents and things of that nature. Typically within a year in a number of countries around the world, you actually need to have patent applications filed before you make any public disclosures or sales of your invention. Now, other types of rights like copyrights, where it's the creative, or trademarks, where it's the branding, those rights don't have time limits per se, although you do want to be as expeditious as possible, because in many countries, and even in the United States, there can be repercussions if someone else applies for trademark rights first. Copyrights, it's a little bit different, but the whole system is set up for it to be, the government didn't set up the laws the way they are in the United States to allow people to sort of sit on their rights for years and years and years and then jump in and say, here I am, it's all mine. So speed is important, but certainly with trademark rights for branding, the key thing is applications can be filed before you're actually selling product in the United States, but to actually get a federal trademark registration in the United States, use will have to take place. But there's even caveats to that. If you have a Canadian entrepreneur and they're already doing business in Canada, there are ways to sort of take your Canadian trademark registrations and push them into the US for a time. And then to renew it, ultimately, you will need to show that there's use in the United States. But ultimately, there are definitely ways to protect your intellectual property rights as a Canadian business owner wanting to sell in the United States. At some level, if you're even already selling in the United States, you can still file trademark applications. And there may be ways to take advantage of what's been done in Canada to kind of push that into the US, especially in the trademark realm, but possibly the patent realm as well, provided the timeframes are correct.
So your response prompted a question here, and it's a personal one.
Sure.
So a few years ago, you may recall that you, I guess you copyrighted some of my daughter's art, as you may recall.
That's correct. I do
Digital
recall.
art. So is there any time limit on that copyright that you put on her digital artwork? Does it come with a timeline? Is that in perpetuity now?
No, it's not in perpetuity. So when an individual copyrights something like artwork and registers it in the United States Copyright Office, an individual will have the life of the author plus 70 years. The idea is to basically allow that copyright to protect the artwork through the life of the author and the life of their offspring. It used to be shorter than that. You can thank the Walt Disney Corporation or company for getting those things extended in the late 90s. It got pushed out another 20 years to life of the author plus 70 years. Corporations, if they receive a transfer of copyright from an employee, for example, or someone else they may have hired to do some artwork, I believe those rights may last 95 years. Off the top of my head, I'm not positive. It's either 95 or 120, but they last for quite a while for copyright. Patent rights are different, so I might as well just kind of add in. Patent rights typically last 20 years from the date your application is filed. Mm-hmm. So usually you wind up actually having patent protection for approximately 17 years. Patents are limited monopolies, and at least the United States government, in theory, doesn't like monopolies. So you get a limited monopoly in exchange for a very detailed disclosure of your invention in your patent documents. Trademarks typically will last as long as you're using them. So you get a 5-year initial, 10-year renewal, but if you're not using it, the rights go away.
So it's up to the owner to actually make sure that they're reconnecting, for example, with you and making sure that they keep the
yeah. So we have very sophisticated docketing systems where we will reach out to people usually somewhere after several years, for example, with a trademark registration or paying maintenance fees on a patent, say, hey, the time's up to file some new paperwork, pay your maintenance fees. So it's actually a good way to, even if it's not a client you're doing a heavy amounts of work for, to stay in touch with them periodically, every few years or so.
So ultimately, the good news here is yes, a Canadian entrepreneur can protect their brand and proprietary property that looking to sell in the U.S. Good news, number one. So number two, obviously nicely segues here, is into how, as an entrepreneur, can I protect my branded and proprietary property that I'm looking to sell into the United States? How do I do it?
Again, it's a question of it depends. If it is starting, let's say it's something inventive, a composition, some kind of mechanical object or electrical object where patent might be, it's new, where a patent might be appropriate. The way to deal with that, there's a couple ways. Certainly someone could reach out to me and understand the patent process, what we need to do the applications, budgets and whatnot. We could start it in the United States through either a provisional patent application or, very technical term, a non-provisional patent application. When I speak to clients, I often call non-provisional patent applications official patent applications, because those are the ones that are very formal. They get examined. Provisional just kind of get your place in line and kind of hold your place there for a year before you have to do your official filing. And then, the patent process takes varying amounts of time. You can pay the patent office in the US to speed up. Otherwise, it's usually about 2 to 3 years to get through the process. Now, it is possible you may have a Canadian business owner who works with Canadian Intellectual Property Council, and they've started the patent process in Canada, and those Canadian attorneys aren't registered or licensed to practice in the US, but they can reach out to someone like me and say, here's all the stuff we've done. Can you sort of transform that and file it as a US application? That is possible as long as it's done within 12 months of that Canadian application being filed. And I could go on even longer about this because there's ways to do it more broadly internationally with what's called a PCT. That's the abbreviation for Patent Cooperation Treaty. And what Patent Cooperation Treaty is, it's sort of an international centralized way to get the patent application started. And it allows a patent applicant to get some initial review of the application done before they designate which countries they want to go into. And the nice thing is both Canada and the United States are members of this treaty. So you can start with PCT and go into Canada and the US. So there's a lot of different ways to do it. There's a similar thing even with trademarks where there's a centralized entity. It's called the Madrid, like the city in Spain, Madrid Protocol, where you can sort of branch out into numerous countries, starting with one sort of national application. So application can be filed in Canada. You can go through the Madrid Protocol, designate the United States or other countries. You could do it the other way, start in the US, designate Canada and other countries, or you can just do direct filings in the United States and Canada. I've worked with US companies who have sold products in Canada and had to work with Canadian trademark attorneys. I've had Canadian trademark attorneys work with me, or dealt with companies that are just registering in the United States. And it's, trademark is a pretty straightforward application process. There are ins and outs. The general standard for can I trademark something is really going to be, is it going to, and this is probably true more or less on both sides of the border. I am not a Canadian attorney, so I don't want to, make representations about Canadian trademark law, but I'm somewhat familiar with it. The general standard you want to think about is, if I apply for this trademark, is there going to be an analysis by a trademark office in the US or Canada that says there's going to be a likelihood of confusion among consumers if I register this trademark? So if someone wants to register a trademark for coffee shops and they're not going to call it Tim Hortons, but they're going to call it Jim Hortons, they're going to have a problem.
Yes.
Okay.
I would think so.
Yes. And that, because there's going to be a likelihood of confusion. I mean, Tim Hortons may be so famous that possibly not, but
I
that
think
trademark
that one would be
application
probably
in all likelihood
called
would
into
be
question.
rejected. So
otherwise, we should get on that one.
Well, yeah, I'm running low on my Tim Hortons K-Cups right now. So,
yeah.
I'm expecting a shipment
I'm
soon.
working on it, Mark.
Yes.
Patience is a virtue here.
It's very popular.
Yes, I know. So, okay. So the good news is, hey, we can get a patent. It's something that is not hard it's doable. And the good news, there's many ways to go about it. And I think, would hope to say that most entrepreneurs are visionaries to a certain degree. So one would suspect that if they are going through the process of patenting their product in Canada, or whatever their branding or whatever their intellectual property is, if they have any type of visionary, they're probably going to look at wanting to do the same in the United States or abroad, outside North America as well. So
certainly from just a pure business standpoint.
Yeah, exactly.
It's a
okay,
big
so
market.
That's good. All right. So the third question I have, and I realize here, let's be honest, we're scratching the surface here. We're not digging super, super deep into the weeds here on the webcast today. But this is just to give people sort of an overview understanding of what's involved. So the third question is what kind of information do I need to provide, to go through this process? And again, how long will it take, generally speaking?
Yes. So I'll just cycle through the different forms of intellectual property. And one thing I should point out that I didn't highlight is there is a variant of patent called a design patent. There are design patents in Canada, the US, and it protects the ornamental features of something. So most of your viewers and listeners probably recall when Apple and Samsung were battling over, they're in heavy litigation. A lot of it was over the ornamental sort of design of the iPhone relative to some things Samsung had done. And so that's another variation where it still needs to be a new, different, novel design. But so I want to factor that in. But when you're dealing with patents, obviously time is of the essence. You want to get to a patent attorney quickly before you really go public, preferably, but if not, certainly well within 1 year of being public, before your 1 year being out there. And the things we always ask are certainly we need details of the invention, technical documents, schematics, diagrams, if any white papers have been written about the technology. And then we drill down even deeper. And this is really a lot of people, if they've worked at big companies will often have inventors prepare what's called an invention disclosure statement. And it details what's the problem that you're trying to solve. People don't just invent, well, maybe some people do, but most people don't invent things for no reason. There's a deficiency.
You're trying to solve a problem usually.
Yeah, you're trying to solve a problem. What is that problem? And then how did you go about solving the problem? And then point to the specific things in your invention that actually solve the problem. And then we start getting into, that's what we need. And we would ask other questions about, are you familiar with related inventions? Because there's requirements of disclosure, at least in the US Patent and Trademark Office, of what's called prior art. Prior art is what's already out there that you're aware of. You're under an obligation as an inventor to tell your patent attorney and the patent office what you're aware of that's kind of generally relevant to your invention. So we'd want to collect all that stuff at the beginning, and then we write the application, goes back and forth. Typically, from being contacted to filing an application, it's usually 30 to 60 days, because we have to gather that information, really drill down into what's novel. We may want to do a search of prior art. That's an option as well that has benefits, but it also has cost, and some people pass on it. It's not required. Sometimes there's bigger time crunch, and we have to figure out how to put as much information in the application as we can in the limited time we have. And you can go back and sometimes make a few revisions after you file. So typically 30 to 60 days from being contacted to get an application on file. Again, if you don't ask the patent office to speed up, you're looking at typically 14 to 18 months to get a response in the US. Canada can actually be quite slow at times as well in their patent office. Like I said, usually 2 to 3 years from application to patent grant, assuming you get it. We don't guarantee it, but and then trademarks is faster in many regards. So with a trademark, someone comes to us and says, I'm going to sell a new brand of water in the United States, and I'm going to sell Baxter water. And
so be a winner, Mark.
We might do a quick search and look and see if Baxter, for something related to water or water bottles, is registered. And if it's not, we would just then prepare application papers. It's a lot less detailed and a lot less costly. Get that on file sometimes within a week or less, but typically within a couple weeks of contact. And then the trademark office used to be a lot faster in the United States, and there's been a big problem in the last 4 or 5 years with a lot of applications coming in from China, India, even within the US, that are really seeking to, in a sense, clog up the trademark docket. So right now, pendencies to get your application reviewed is about 10 to 12 months. But after that,
it's a process more than an event. Let's just be clear here.
Yeah. And typically, though, assuming everything's fine, you get your registration a couple months after that. It's all good. Copyright's pretty easy once we have the stuff, whether it's artwork or, some literature. We submit the application within a week or two, and the Copyright Office pendencies vary a lot, and it just depends on what it is. Sometimes if it's a book, it's a couple months. Sometimes if it's more involved, it could be 9 months. But once you're a lot of these things, once you're on file, I wouldn't say you have enforceable rights, but you kind of like no one's going to be able to jump in front of you, which is good.
All right.
And I would say a lot of that is probably true in Canada with the patent and trademark system.
You just took the question right out of my mouth there, which was
Yeah,
really, how different is that process for an American entrepreneur looking to basically do the same thing? Maybe they've got the product up and running in the United States, and now they're thinking, you know what? It's
I've been in that boat
48
many
million
times.
people north of the border there. Maybe we should be looking at them as a new market. Uh, I realize that you're not an attorney in Canada, but I would imagine you would have some idea. Is it similar? The process relatively similar to what's involved in the
Very
United
similar.
States?
Very similar. If you have clients that are in the US, maybe they're from Canada originally, they live here now, but still do a lot of business up there, what have you. The process is extremely similar, especially on really for patents and trademarks. The process is very similar. Gathering the information, figuring out what the invention is, writing it up, very similar. And even the law, I mean, again, I'm not a patent attorney, but having dealt with or Canadian attorney, but having dealt with these things, the law and the rules are quite similar. It's there are ways to cause the patent office or trademark office in Canada to patent office for sure, you can ask them to do things to speed things up, but the likelihood of confusion, the same ideas, like, is the invention novel? It's not something that's already out there, or it's not an obvious combination of two different things. Those rules are very similar between the US and Canada. So I'd say the process is very similar overall.
All right. So, as you know, the webcast is obviously watched here in the United States as well in Canada. We do a lot of work with kind of an eye to the north, if you will. And with that in mind, what advice would you have for a Canadian entrepreneur, Mark, who's looking to expand into the US? Like what kind of direction or suggestions could you provide just to help them with this process? I know we're kind of looking at intellectual property, branding, that sort of thing. What are your suggestions, or what are your thoughts?
Yeah, in that area for sure, I would, if you're a business that has branding, if you're an established business in Canada and you've got trademarks in Canada, you definitely want to have your trademark attorney reach out to a counterpart here in the United States, someone like myself. If you don't have Canadian IP counsel, it still would be really wise to talk to, an attorney like myself who's dealt with, only IP in my entire career and can ask you a number of questions. Do you do research and development? Do you invent things in the course of your business? Do you have branding that has a lot of value and importance to you? Are there creative things, artwork, literature, even website design, sophisticated graphics that are really important to you, that you're coming into the United States and you don't want to be ripped off, or you want to reduce the risk of being ripped off as much as possible, and you want to be able to do something about it if you are. Those are the kind of things that, if the entrepreneur in Canada is thinking about that as they're coming down here, definitely reach out to IP counsel. On the flip side of that coin, because there are businesses that it may not be sinister, let's not go there, but they're going to come in and they want to sell something, and they should make sure, maybe branding is somewhat important, but the patent thing's not. You still want to make sure that you are not going to step on someone else's toes who has a patent or has trademark rights, and you're going to open up a business. Like you want to do Jim Hortons in Michigan and Minnesota. Bad idea. And so that's an obvious example, but let's just put it this way. One of the things that in the US, that I wouldn't say it's completely different between the US and Canada, but the US legal system, and in these cases like patent and trademark cases, is very expensive. So it makes a lot of sense to invest a little bit of money up front to make sure you are, as best you can within reason, not going to be violating someone else's intellectual property rights, because they are valuable. One of the things I preach to my clients all the time is intellectual property rights have value to your company. They have value because you might be able to stop someone else from doing what you're doing and clear out space and have a bigger segment of the market for yourself. They have value if you're going to go through a liquidity event, and the deal makers and the lawyers and the valuation people see IP, and it adds value to your business. So it's really important to have it. It's really important to make sure you don't violate someone else's. And frankly, to do those analysis, it can be expensive, but most lawyers are going to be.
Litigation could be more expensive.
Litigation will be more expensive, most likely. And the reality is, I deal with all manner of clients, from startups to companies that get sold, and everything in between. Size wise is all different. And, as a lawyer, I have to be cognizant of budgets. I have to be cognizant of costs. And, I do my best to work with clients within their means to give them the best sort of ROI. They're investing in me to give them some rights, some information, whatever it is. And if they tell me how much they have to spend, I will do my best to maximize their ROI and give them as much information and value as possible.
Okay, before we wrap, I got one question, and we just want to maybe a quick response to this one. So you're a U.S. attorney representing a U.S. company, and you discover that a Canadian company has and somehow infringed on your U.S. client's intellectual property. Even though this Canadian company has no exposure to the U.S., doesn't sell their property to the U.S., are they still liable to U.S. patent law, intellectual property law?
That's a great question. And if memory serves, there either was just a Supreme Court case, a U.S. Supreme Court case about the fancy legal word is extraterritoriality. Do U.S. patent or trademark rights extend beyond the borders? And the answer is typically no. There are exceptions. I wrote a law review article when I was in law school about Cuban cigar trademarks. And there was an embargo in the United States. So in theory, Cuba could not have any trademark rights in the United States. And there was a U.S. tobacco company that started using a famous Cuban trademark for cigars, Cohiba. That was like their flagship brand. And there was years of litigation about whether a famous trademark outside of the United States could still have some semblance of protection. And those questions are very esoteric. And the answer is typically no, because trademarks have to be in use in the United States. But if something has so much recognition and so much fame, for example, if Coca-Cola wasn't trademarked in the United States or sold in the United States and existed outside the US, could they somehow enforce their rights in the United States? Probably not, but there are these very esoteric international conventions where you'd want to have an attorney really look at that carefully to make sure. There's some very esoteric international conventions. One's called the Paris Convention. There's another one called like the Inter-American or Pan-American Convention. There's a bunch of them. The Berne, B-E-R-N-E Convention. I'll tell one more story. I had a client, was referred to me. He bought copyright rights to a book, and it was U.S. copyright rights. And he comes to me and he says, I have a problem. I said, what's the problem? And he says, there's some guy who's made copies of the book that I have a U.S. copyright on, and he's copied them in Portuguese, and he's selling them in Brazil on Brazilian eBay. Is there anything we can do? And I said, yes, there is. there's this Bern convention that it's like all the signatories to this convention have to give like member countries some bare minimum like intellectual property rights and sort of recognize certain things. And I literally found an in-house lawyer at Brazilian eBay. It's called Mercado, which is market, Mercado Livre, which is like free market. And I found her on LinkedIn and reached out to her, told her my situation, and I actually got the client the ability to shut that down on Brazilian eBay with a US copyright.
Interesting.
So it's very esoteric, but it's possible.
You know what, Mark? I could see we could probably go on here for another 2 hours, but in all instances, this is probably a good place to wrap up this time. No, we've included your contact information. So the folks watching today, if they're watching again, they're going to see your contact information. But even that said, what is the best way? As someone watches or listens today and says, I need to talk to this guy about a product I'm looking to get copyright or patented, or I want to protect myself, what is the best way for them to reach you?
I would reach out. I would start with an email is the best way to go. Give me a heads up. I saw your thing on the One Capital podcast and have some questions for you. And I'm generally very responsive and glad to talk to people. And, I don't charge for like an initial call or anything like that. So glad to chat. Do I get to ask you any questions, Wayne?
Not today, Mark. No questions today. We'll undoubtedly, I can just tell that we're going to have a follow-up here at some point. So, but I do want to thank you for joining me today, my hockey buddy, Mark. This has been awesome.
Absolutely. That was going to be my question.
I have a sense that if we ever did a hockey podcast, each episode would be like 3 hours. I could just tell right now, but yes. I want to thank you again for joining us. Mark Nielsen is a partner with Scheef & Stone. He joined us from Frisco, Texas. His practice focuses on all aspects of intellectual property, particularly litigating patents, trademarks, and copyrights. Thanks again to Mark Nielsen.
Thank you for having me.
I look forward to bringing you the 3 Questions webcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our YouTube channel. And to receive notification of when our latest webcast has been posted, please click on the notifications bell. Lastly, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meet with Wayne. Thank you and see you soon.